Welcome to IP Goes Pop, your source for exploring the interface between intellectual property and pop culture. The IP Goes Pop podcast series is created and produced by Volpe Koenig, an intellectual property law firm based in Philadelphia, Pennsylvania. Visit us at vklaw.com. This program should not be considered legal advice. Please consult an attorney for your specific situation. And now your host, intellectual property attorney, Michael Snyder.
Cheers and welcome, listeners, to IP Goes Pop, the podcast that is directed to the interface between intellectual property and popular culture. Today we have a topic, it's a great topic that is rooted in all of popular culture. It has to do with the right of publicity, not to give it all away. And I'm very lucky and very excited today to have, and I really don't know how we booked him with his schedule, but we got the founder of Volpe Koenig. He is my mentor. He is our fearless leader. Unfortunately, sometimes a shoulder to cry on, but I'd like to introduce Volpe Koenig founding shareholder Anthony Volpe. Anthony, welcome.
How you doing, Mike? It's a pleasure to be here, and I hope we can enlighten some people about these rights of publicity.
And I know you go by Tony, and I know that you will be unafraid to take this conversation on this podcast wherever it goes. And just another reminder to listeners, this is not legal advice, but we are reviewing some of the law that has to do with some really interesting areas of popular culture and intellectual property. So to set the table, this week we're going to talk about the right of publicity. Now, sometimes we have topics that sound like what they are. This does have the right of publicity is about publicity, but it's really about more than publicity. When we think about publicity, we might think about just promotions or promotional activities or advertising, but it really is more than that. This is about, not unlike patents, not unlike trademarks, it's really about control. It's about control and it's about dollars. It's about controlling your likeness. The right of publicity has to do with an intellectual property right that protects against the misappropriation or improper use or use without permission of a person's likeness or things that indicate their identity, like a nickname, like their voice. We'll talk about singing voices, like their photographs of them or their image somehow. All of those are covered in some ways, or there have been attempts to cover them in some ways with the right of publicity. And unlike patents and trademarks, there is no federal, and actually trade secrets as well, there's no federal law or no federal statute that covers the right of publicity. So it's based on what we call common law, which is law that just develops through cases, or by statutes in state law. So, what's the value? Well, especially if you're a celebrity, your value in the right of publicity is in a lot of cases you'll see, and when I say cases, I don't mean legal cases, but a lot of instances, you will see a celebrity sign an endorsement deal that is more than what they make for, let's say, if it's an athlete playing their sport. So the right of publicity is incredibly valuable. And unlike a patent or trademark, you don't have to file for or register it to help support that value. And in Hollywood, I'm sure I have this experience. You may too. That you'll be watching television and you'll see you'll be watching a commercial and you'll hear a voice. And sure enough, it'll be the voice of a famous person. In fact, I think sometimes we spend more time trying to figure out who the famous celebrity is than to watch the actual TV show that we're watching. But that being the case, this goes to how much this has grown. In fact, a lot of established celebrities have taken over a lot of the voiceover and commercial work from unknown actors because of the incredible value and the money that's in stake in these. So let's take it, Tony, let's take it back to the very humble beginnings. Surprisingly, the law of the right of publicity did not start with a famous celebrity. It started in a case called Roberson v. Rochester Folding Box Company out of New York in 1902. Tony, can you tell us a little bit about the background of this case and how it really started from not celebrity, but actually very humble beginnings.
Well, I think if I might, make one comment on the celebrity aspect of this first, because I think it might help to put some of this in context. You mentioned how some athletes can become very wealthy on the basis of the uh, endorsements and so forth, and people have pointed out that in all likelihood, um, Michael Jordan probably became a billionaire in some small part based on his being the Nike endorsement spokesman. And so that was Michael Jordan with just his own persona, his athletic talent, and so forth. So it was all about Michael Jordan, and so that was a fame that allowed him to do endorsements, and people recognized it immediately. But then you still have to, in this area, you have to somewhat divide between um, the athlete or the actor or something. For instance, there's some things around Sasa Stark from Game of Thrones, where dressing up like that is not her. That's not the actress. You know that she is not the act. It's just the actress acting a part. So the persona of that part is not owned by the actress as such. Whereas Michael Jordan, the athlete, does own the Michael Jordan imagery that made him a famous spokesman for Nike and made him quite wealthy.
So two things about what you just said. One, I do think it's important to separate the character, the protection of a character, let's say by copyright, separate and apart from a film or movie or established in a comic book and all of the Marvel Avengers. Robert Downey Jr.'s right of publicity is based on being Robert Downey Jr., based on being Iron Man. The Iron Man character, that's owned by Disney now, but still such a valuable right. You certainly couldn't just print Robert Downey Jr. T-shirts without permission. And what you said about Michael Jordan and the really underscoring the value of it, would he have become even the most famous athlete? Would they become would they have $1 billion based solely on contracts through their athletic career? And the answer is highly likely no. I can't think of another one. But from endorsements, from being the individual Michael Jordan and his likeness being on, sneakers or commercials for Gatorade, certainly that would be a risky move to try to copy that, but it also shows you the incredible value of it. So that's a really good point. And also, I think also throws into stark contrast how monetarily, how little was at stake in the original case that started this all.
Yeah, going back to your original question about Rochester, uh, Roberson and Rochester Box Company. This was a case of someone who was not at all famous, had little to no celebrity, and was pictured on the boxes, which clearly were from the box company, and it was part of an advertisement. And this was in New York State, and she sued. And what happened to her, because New York State did not recognize the right of publicity as such, or actually a right of privacy, and separated right of privacy from right of publicity. She was unsuccessful because she was not a famous person. It was in the realm of an advertisement. There was no dispute about the fact that the box was from the Rochester Box Company. So this was a case of someone who, although imagery was used, because there was no fame or no recognizable personality in it, she was not successful, which, going back to the Michael Jordan example, quite clearly, if Rochester Folding Box Company had put Michael Jordan's photograph or used Michael Jordan in any way in connection with it, without having authorization by Michael Jordan, that would have been quite a different outcome. And it it also brings up what Mike said earlier about the fact that you have state law covering this. The vast majority of these cases seem to be bi-coastal in New York and California because of the entertainment industry concentration in those areas. And yet the two states have somewhat different laws regarding what your right of publicity is, as well as your right of privacy. So uh, it can become an issue about where the event takes place and what the state law is in the area where the event takes place.
So, talking about at the time of this case, you have the plaintiff, a woman, I believe, who worked at the company. They took her picture. Um, they thought it would be great to use on advertising. They put it on the package of flour. And there were something like at the time 25,000 instances or posters or packages, which, if you think about it at the time, that's a lot of reproduction since this is 1902. And she was a very shy person. There's some interesting stories. We're actually going to put up links that show the actual picture of her on the flower package. But if you think about it at the time, before celebrities completely took over the advertising game, let's say, there was a time, my grandmother would send me to the store and say, "Get me the package with the girl on it," or "Get me the package with the man on it." And, you know, the imagery does become the brand in this case, if you know what I mean. So they really did, if you look at it from a privacy standpoint, they did take it. They did take something from her, if you think about it, Tony.
Yeah, it is kind of interesting, largely because you say with these posters, um, if you had something like going back to your imagery on a package, if you had something like Clabber Girl baking powder, uh, that would be on a can of baking powder. That might go away. You might eliminate it once that package was gone. It was done. But this, where you had something where thousands of people could go buy it, as you said. This was at a time when printing was nothing like it is today. I mean, we're talking about something that was back, in the early 1900s. So people walking by posters, this was sort of the golden age of advertisement and the start of consumerism in this country. And yes, whether she wanted it or not, there was a sense of celebrity that came with it. That you know, as you say, being a shy person, she just may not want people to recognize her when she stepped onto the subway. That she was the girl in the ad for the flower poster or the folding box company or whatever the subject matter may be that she's now associated with.
And it wasn't that it was negative or anything. It's just the kind of, by the way, I'm going to tie this directly into something that is happening right now. So this is kind of an original thought, or starts the thought of the right to be left alone, which is the concept under the new privacy rules, especially out of Europe. So we're talking about in 1902, what may have been the beginning of that right to be left alone, which now ends up with these massive internet laws that are international in nature. So this isn't something that has gone away. In fact, if anything, it's still a battle that is being waged on the internet now.
Oh, I agree, and I think it's somewhat exacerbated by um, all of the things that can be done so quickly today. You hear about athletes suing because someone took a picture of them, put it on Instagram, and then somebody else takes that picture from Instagram and puts it in something else. And what you have today is the dissemination of these things. um, Although we were kind of marveling at the number of posters or reproductions for the Robeson, the reproduction today of all of these things is tremendously faster and can spread across. It's viral.
Oh, sure. Yeah, yeah. Once it goes viral, if you think about it, if you were a celebrity and you posted a picture and it only received 25,000 likes on Instagram, you would fire your publicity person.
Yes, yeah, right. Um, but in today's age, there was used to be the saying that no publicity is bad, but in today's age, where people can do things like photoshopping and so forth, um, today we're seeing the Facebook and some of these online services taking down, would have been doctored photographs and so forth. Now they don't apply so much because a lot of them are politicians or famous people, and there's sort of a different standard where you've put yourself out there. But if you're that one person who happens to be at an Eagles game or at a stadium or something and do something a little foolish, and somebody uh, takes a photograph of it, you can become sort of the unwilling celebrity of the week
Right,
for
right.
something that normally would not have attracted any attention beyond the people that were around you.
It's a perfect setup for the next case because it is about exactly what you said. It's your right of publicity versus newsworthiness, or how newsworthy are you, or were you part of a scene that was newsworthy or something that happened? So the case is Zacchini v. Scripps-Howard Broadcasting. It's a Supreme Court case. It's from 1977, which is kind of interesting that there was a pretty big lapse of time between the seminal Roberson case and then this next right of publicity case. And here, speaking of popular culture, uh, I guess in 1977 there was still a time that the Human Cannonball Act, before the internet really took over, people actually had to climb into cannons and shoot themselves across a field to entertain people. So a lot has changed even since 1977, which is not that long ago, or I'm going to pretend it's not that long ago. So Tony, tell me a little bit about this case and kind of the balancing that went on in this Zucchini case.
Well, as you said, the underlying act, or the zucchini's underlying event, was that he was a cannonball, and so he was shot into a net, and I guess it was some number of feet, a couple hundred feet away, and that had been videotaped, and this kind of interestingly enough, kind of moves into that. Idea of the technology moving forward, because now in 1977 it gets a lot easier to videotape things, and so the reporter for the company, which was incidentally, it was the Howard Broadcasting Company, and I didn't check back through this, but I wouldn't be surprised if this was the famous Howard, the famous aircraft maker. But in any event, what happened here with what upset Zucchini was that the reporter showed it on television later the same day. And the position that Zucchini took relative to that was it was an unlawful appropriation of his professional property or performance. And the reason for that is, remember, he was making his money by people watching him get shot from a cannonball or act as a cannonball.
Right, a tough way to make a tough way to make a buck, if you will.
Yeah, and so if everybody could see him for just gratis being shot from a cannon as a cannonball, then it's not likely that people were going to go when he was in town to see him actually shot from the cannon. So it was taking away his opportunity to perform professionally. And he originally was kind of disappointed by the Ohio court, which dismissed a summary judgment, and then later the Court of Appeals reversed it. And what the court said then it was that Zucchini had a right to the public value of his performance. But unfortunately, there was another earlier case from the Supreme Court that had reversed the judgment on the grounds that it was a case for the newscast, the constitutionally published things of public interest that would have been um, normally of interest to the public and newsworthy. So, absent an intent, a specific intent to hurt Zucchini, then it was a case where Zacchini could not recover because there was no non-privileged purpose. Namely, it was a newsworthy event.
And what I think you hit on the fact that they basically look, there's not much to the human cannonball act. You get in the cannon, you get shot from the cannon,
Right.
everyone holds their breath, and then you land, hopefully. And that's the act, right? So if you just showed I'm sure there's a lot of buildup and fanfare, but if you show this reminded me of the Evil Knievel situation where if you were to show him, it's an hour buildup and then he jumps over the buses and he doesn't land and he bounces around and then he's okay. That's the act. If you show that, you're kind of taking everything. But going into the next case, it's interesting. You had mentioned it earlier, and it's this dichotomy between a character uh, versus the individual. And it was kind of interesting because there is a line where they meld together. Where does the character become the individual? This was Lugosi, as in Bela Lugosi versus Universal Pictures, 1979, out of the Supreme Court of California. And here, the argument really was about Bela Lugosi. Someone copied the Count Dracula character, but they copied his version of it, let's say. So at a certain point, his family, this is his heirs, he had already passed. So his family was claiming rights to his version, if you will, which became his persona. And this is to steal the imitation from Adam Sandler, it's kind of the blah, 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 that version of Count Dracula. And Tony, I guess what were the factors here and what happened to the family or the heirs in this particular case?
Well, I think you made a point there that is important here, and that is, could anyone else play Count Dracula? And if someone else played Count Dracula, would Lugosi have had any rights in that? And the answer to that is no. But what happened here, as you mentioned, is that this was a case where they used what had become his persona or his imagery of the Count. And so the question that came up is whether the right to exploit his name and the likeness was a property right that his family could contest other people's use of it. And the court in this case, let me be sure I'm right about it. Yes, it was 1979. The California Supreme Court held that the right to exploit his name and likeness is personal to the artist and must be exercised, if at all, by him during his lifetime. And the distinction, and this will change subsequently, but the distinction there was, um, did Lugosi actually did he work and use that personification for commercial purpose other than just the acting? And the question turned on whether that property right and his presentation of Count Dracula was something that he could pass on to his family. And at the time in 79, that was not possible, but California subsequently changed the law and it's no longer necessary because if you look at something like Elvis Presley's estate, they have made virtual fortune on licensing Elvis Presley long after his demise.
So let me interrupt for 1 second on that point about the heirs and the estate. So Um, is it the case that the heirs or the estate, the children will always, if one of the celebrities passes away, do you always get the right as their estate to keep protecting it? Or is that another, what happens, I guess? And does it matter where you are?
Actually, it does. It can be very conditional. In some cases, you have now a statute which will protect, I believe it's up to 75 years for somebody who actually, say, an actor or an actress who dies. currently in the family takes the estate over. And then the state of Indiana actually has a separate law which allows you to get 100 years. So if you look at it in terms of how does it relate to other laws, it's somewhat like copyright law, where you have a term that goes for the life of the author, in this case, the life of the person, and 75 years after. So there's a trailer, if you will.
If you think about, I mean, you say like there's basically you have some runway. If you think about it, perhaps the person did not exploit their likeness during their lifetime, perhaps, and afterwards, maybe the family will. I mean, I have seen instances like that. For example, in related, Dr. Seuss, the children's author, refused any merchandising, and now you can get one of his characters and even his likeness on anything because of the estate.
Well, and that goes back to a comment that you made earlier about the differences in the state laws that relate to this, because um, the California law tends to be a lot more liberal about finding that there is a right both of privacy and publicity, and the New York law still tends to be somewhat more restrictive in that area. And interestingly enough, we had said earlier about how it might depend to some degree on where the event takes place. But since a lot of these questions become a conflict of laws among states as to which state should prevail, um, it's one of the reasons that most of the famous estates have based their agent in Indiana, where it has the longest term for being able to basically sell and use and benefit from perpetuating that same imagery. Now, some of that does probably change when you get further away from people, famous people. Michael Jordan is still alive and quite famous, and people know him. But as famous as a Mickey Mantle was, I don't know if a Mickey Mantle today would carry any near the weight or the endorsement value that you might have from a Michael Jordan.
And also it depends on, the audience for it, and it also depends on, like anything, what are people how scarce is the memorabilia, because a Mickey Mantle jersey, signed, or even a picture to the right person, you know, could be incredibly valuable even today. But the I want to skip through some of the cases that are in the line of case, or go through them. Rogers v. Grimaldi is from 1989. It's another New York case, like you said. So much coming out of New York and California because that's where the stars are. That's where the industry is. This was about a movie called Ginger and Fred, made by famous director Federico Fellini, and the estate of Ginger Rogers sued. But I think really there, the balancing was pretty clearly artistic First Amendment right versus the right of publicity. And I don't believe the court was convinced in that case that they really took her personality and kind of was like an homage or a tip of the hat toward, Fred and Ginger.
Yeah, I think you brought something else in that makes uh, can make a difference here, and that is if you talk about First Amendment rights and, like you said, also artistic expression. This was not a case where Fellini was actually using Ginger Rogers and Fred Astaire. It was really about two other dancers, and they were somewhat, if you will, parody of Fred and Ginger. So it is a little different. They were not specifically trading on the fame of that dance team, but some would argue that, well, but for the fact that there was a Ginger Rogers and a Fred Astaire, would anybody care about the parody, and would the movie would it have been anything more than Fellini wasting some film on two people that nobody really cares about. So the artistic expression versus the right can be an issue, and I think it can be a fine line. And as we say in the trade, you can be slicing the salami pretty thin to make a distinction between them.
I wanna fast forward ahead to two really interesting cases or facets of, let's say, personalities of perhaps celebrities. So the sound alike cases. Now, if you think about it now, we have, if you have a very distinctive voice, if you are a Morgan Freeman, I think, if someone imitated Morgan Freeman's voice to sell a product, I think everyone would believe that very distinctive voice to be him if it was copied correctly. And I think that it's a huge, I mean, part of the Morgan Freeman business is being in the business of having Morgan Freeman's voice. So it makes sense that that is going to be protected in this sphere of what are we talking about when we say right of publicity. I mean, that is his, that is his calling card, if you will. And there are other people that are coming up, through the celebrity ranks like him, where you're hearing their voices on commercials, and you're, especially car commercials, and they are becoming the, Dennis Leary. I think it's for Ford trucks, but he's the voice of the truck. When you hear it, it becomes associated. That has a value. And one of the first sound alike cases was Bette Midler versus Ford Motor Company in 1988 out of the Ninth Circuit, which is California. One of the two big places, as you said. So in this case, it was a sing alike. So they had someone sing like her, and I don't think she had much success here.
No, she didn't, but I think if, as you said, it may again have be a case of being early, because at the time, I'm certain, just like a lot of tribute bands or tribute singers are in clubs and small venues and so forth, I think there were a lot of people who could do a tribute, and because there was a distinction, and I think part of that may have been she was never necessarily connected with a truck as such. But if you think about the race car driver, Dana, can't think of her name right there. But if she was associated with that and it was a voice alike, question is, would that be different? Would that be different because the sound of that is coming out of that voice for advertising is someone who has sort of a direct connection with a seat in the vehicle. So that voiceover is a little bit touchy, I think. But I think when you get to someone, as you said, like a Morgan Freeman, someone that is so distinctive that I think it's somewhat different, because at that point of distinction, the people will focus only on the voice.
So in the 90s, robots were very popular. Um, and there are two different robot-based or robot-adjacent cases about the right of publicity. One was a case involving Vanna White of Wheel of Fortune fame, again in California. Samsung Electronics had done a commercial with a robot and a game show that was like a Wheel of Fortune game show, which is Hangman. But um, she had, she had fame as the letter turner on Wheel of Fortune, and had her own kind of run of um, celebrity, and still doing it. Uh, that was a case where she sued under the right of publicity. And then in another case in the Ninth Circuit in 1995, a sports bar, and this is based on the TV show Cheers. Everyone knew that Norm and Cliff sat at the end of the bar in Cheers, and they created two robots, not exactly like Norm and Cliff, but enough that anyone walking by would know who it was supposed to be. And they spent years in litigation until they finally settled. with this bar that had, and in fact, there are airports you could go to now and see this bar, and you'll see them in the corner. And if you were ever a fan of the TV show, you'll see Norman Cliff. But getting back to the biggest of celebrities, I guess, was a case where swinging all the way across the pond, as they say. So this is Michael Douglas and Catherine Zeta-Jones versus a publication in the UK, Hello Limited. They had a photographer for their wedding. It was a closed wedding, and they gave specific permission to one outlet, and they were paid generously for their wedding photos. Another photographer got a picture or snapped a picture of them in their wedding clothes and sold it to a competing magazine. Now, here we are. It's the UK, but it's still an interesting case and relates to the right of publicity and how it impacts around the world. So here, the actual married couple, Michael Douglas and Catherine Zeta-Jones, were seeking to control how the imagery of their wedding got into the public. And in fact, you'll see this today where stars will contract for their first baby picture. You know, they have a child, everyone wants to see it, and they will sign a deal with a certain publication, you know, People, Us Weekly, Entertainment Weekly, to show the pictures. So again, we're talking about a significant amount of money, and here they did prevail against this publication. So although it's in the UK, it is interesting that I think that you do see a lot of cases out of London where you have these, or the UK, where you have these tabloids and they'll climb up a tree and paparazzi, and it is supposed to protect against that. But here it really was about competition.
I think you've hit on a difference here again that's based on that geographical location. You have Europe becoming increasingly defensive about or sensitive to people's rights in this area. You have the royal family doing a similar thing, wanting to control the photographs of their children. And in the second part of the Michael Douglas issue, you have the photographer who had, in a sense, gotten this very valuable um, commodity that obviously was looking to sell, which was obviously going to be part of the value for these pictures. And if people can sort of pirate and so forth, you have a problem. But you also have the issue that you have but you're back to your right to just take a picture of anyone as long as you're legitimately there. So, unlike being in a tree, if somebody could get a valid picture, just their own snap of a celebrity, that's different until they start using it commercially. And one of my favorite cases where somebody used something commercially is the Johnny Carson versus Johnny. Here's Johnny portable toilets. Um, for those in the audience who would remember, Johnny Carson always came on stage with Ed McMahon yelling out, "And here's Johnny." Well, of course, they put these portable potties out there with "Here's Johnny," and Carson took some offense to that, and the Sixth Circuit Court found that the district court had viewed the right of publicity too narrowly, and that the defendant had appropriated the identity. And it's kind of interesting because we were talking a little bit in the robot problem about how much they look like something, whether it's Vanna White or the Cheers characters. Uh, Clearly, this rectangular um, box with a door on it doesn't look like Johnny Carson. Yet it was part. The court found that they were taking some of his identity.
And by the way, let me just ask, is there any truth to the rumor that you used to have young associates introduce you as in court as "Here's Tony"?
Yeah, yeah, with the judge clapping, right?
Right.
Or usually it was banging the gavel saying, "Get the dummy out of here." I'd like to go back too because there just 1 minute to the voiceover things. We were talking about how voices make people into celebrities for advertising purposes. Putting aside that Matthew McConaughey made the movie The Lincoln Lawyer, there's another case where his voice is so distinctive that he's been in commercials, and a lot of those commercials, uh, to a large part, before you ever see what is the advertisement or the product they're trying to push. Um, it's Matthew McConaughey's voice. Sometimes even in what might be thoughts in his head, but always in his voice. So that's one of those cases again where, that today a celebrity would be able to make quite a bit of money doing something like that.
We've come all the way from 1902 from a flower package with a photo of an unknown, all the way to Matthew McConaughey, driving his Lincoln around and saying kind of Zen-like quotes, which nobody understands, or maybe a few people do understand. But it's really, so this is, although it doesn't get the right of publicity itself doesn't get the publicity of patents, trademarks, trade secrets, those type of things. But there's, some really interesting cases. It almost always now involves, more famous people. So, again, Tony, I just want to say thank you for coming on IP Goes Pop, our Volpe Koenig podcast. I hope you come back again. We have a lot of different topics we could talk about.
Oh, happy to come back, and we didn't have a chance to get to it, but I think if people are interested in it, there's also some real interesting cases around pop bands and the new stars, if you will, and how quickly they can get once they hit that fame based on today's instant electronic fame electronically and spreading. Those pop bands can get caught up on these same things. So I anticipate that this is at some point, I think the idea is going to come about that publicity and privacy are going to get closer together.
Yeah.
And I think maybe Europe is a little bit ahead of us in doing that.
Well, for IP Goes Pop, thanks for listening. I hope you enjoyed it. And also, just so you know, Nike, if you're listening, if you need a different image, Tony and I are both available for a full line of sneaker and athletic wear. I'm not sure what sport it would be or if it would even be very active at all, but we are available. So call us or email us at the Volpe Koenig, vklaw.com website. And again, thank you. This is IP Goes Pop. Hope you stay in the public, and we will see you next time.
The IP Goes Pop podcast series is created and produced by Volpe Koenig, an intellectual property law firm based in Philadelphia, Pennsylvania. Visit us at vklaw.com. The IP Goes Pop podcast series is created and produced by Volpe Koenig, an intellectual property law firm based in Philadelphia, Pennsylvania. Visit us at vklaw.com.